Hi, this video is about what to do if you've been made redundant instead of being put on furlough leave. Do you have any employment rights? My name's Alex Monaco, solicitor, owner of Monaco Solicitors, employment law specialists for employees only. Okay, do you have 2 years service or not? That means, have you been employed for 2 years or less? Because if it's less, it's a lot harder for you. You don't have the right not to be unfairly dismissed under Section 98 of the Employment Rights Act 1996. So that means you're going to have to rely on some other legislation if you've got less than 2 years service. It might be health and safety legislation. So if you were made redundant falsely, but the real reason was because you were actually concerned about health and safety at work and the risk of contracting coronavirus, then you're entitled to compensation, all the salary you've lost, and also going forwards. Watch my other video about that, okay, about furlough refused when staying at home for reasons that your workplace is unsafe due to the risk of coronavirus. Other legislation, if you have less than 2 years service, well, disability discrimination, if you're vulnerable or shielding, or even a member of your household is, then the Equality Act 2010 means that your employer should make reasonable adjustments. Arguably, putting you on furlough instead of making you redundant would be a reasonable adjustment. Similarly, if you have age-related vulnerability, you could argue that it's age discrimination not to furlough you. All right, what to do if you've got more than 2 years service? Well, this time the law is your friend. If you've got more than 2 years service, you have got rights not to be unfairly dismissed. That means your employer should really consider all the circumstances before making the extreme step of making you redundant. If furlough was an option, then why didn't they furlough you? Now, each case will be different. Broadly speaking, there's two types of cases here. One type is where the business itself is changing. Maybe the whole business model is changing. So even after the furlough scheme ends and even after lockdown ends, you won't be needed anymore. Well, the business could say, fair enough, they could justify you being made redundant. On the other hand, what if it's just a temporary closure of the business and they're going to open again, business as usual, when all of this blows over? In that situation, you've got good grounds to argue it's unfair dismissal to make you redundant without considering furlough leave. And what about consultation processes for redundancy? Again, you need to have more than 2 years service for this to apply. If you've got more than 2 years service, then your employer has a duty to give you a proper consultation. They can't just make you redundant the next day, for example, without any warning. They'd have to have meetings with you, discuss alternative employment, allow you to apply for such jobs if there are any, maybe compare you to other people who are home working. So there has to be a process there. If there are more than 20 people being made redundant, then there has to be an even greater process. Normally, that's a 90-day minimum period of consultation. In these coronavirus times, your employer might be able to justify shortening that period. But even if they do, it's still going to be at least a good couple of weeks before they can say. Either way, have a look at some other videos on our YouTube channel, have a look at our website for the articles on there, and try our free coronavirus app on our website, which writes legal letters for you to send to your employer. Hoping your family and yourself stay safe and well.